You should be definitely getting into the swing of this now. I will introduce some of the more established parts of free movement of goods law. I'll go through some parts quite quickly. You'll need to fill in some more specifics in your notes using a good textbook. I'm going to look at the structure of the case law, explain how it works, and then I'm going to look at some case studies with you so that you can have a look at how free movement of goods law works in practice. And this, of course, will support your learning in your workshops, but also in the final assessment. Now, here's a slide from the tutorial on the electronic workbook, which you probably recognise. And here is a question for you to think about right now. Which of these types of claim, type 1, where the party claims that EU law is not valid, or type 2, where the party wants to claim rights under a provision of EU law, which of those types of claim are most likely to be engaged in a free movement of goods problem question? Type 1 or type 2? If we were together, I'd get you to do a show of hands in the lecture theatre. So that's right, it's type 2. So we need to be thinking, as we go through the material on free movement of goods, how can this EU law right be enforced? And how does national law or national conduct infringe rights under EU law? And who is bringing the claim? Is it an individual, a company, a person, in a national court with a possible preliminary reference to Article 267 under Article 267 TFEU, or is it a member state or the Commission bringing claims under Article 259 or 258 TFEU respectively? Now, this is mainly a revision slide. If you're not sure of the answers to these questions, you need to go back to the previous lecture and use some textbook materials to support your work. We've covered already the difference between positive and negative integration, integration through legislation as opposed to integration through litigation. We've spent some time thinking about the legal bases for EU action in internal market law as positive integration, and in particular you covered this in your workshop on Article 114 TFEU, both workshops in fact. And we've talked about the legal limits to this kind of action and the case law on Article 114 TFEU, where it does and does not give power and competence to the European Union institutions to adopt internal market law. And then we've started looking at the core treaty provisions for negative integration in terms of the single European market. And we looked at, in the last lecture, that all of the different types of factors of production that move in the internal market. And here we want to focus on the provisions on goods, on products. I don't think we've yet covered what the legal definition is of a good or a product in EU law. That's a pretty straightforward point, doesn't need much explaining, which you can also find in a textbook and add to your notes. The definition is products which can be valued in money and which are capable, as such, of forming the subject of commercial transactions. And there are some boundary products like waste or parts of the human body or electricity or lottery tickets, and there is case law on those boundary products. And then finally, we want to think about what types of barriers are there to free movement of goods. And we started thinking about that in the lecture last week, but we're going to spend some more time thinking about that and deepening your knowledge and understanding of that in the lecture this week. As ever, if you want to talk about any of these things or you need more help, please just get in touch. So, we already know that the internal market is an area in which factors of production, goods, persons, services, capital, move freely. And here in this lecture, our focus is on the movement of goods, of products. The key treaty provisions here are Articles 28, 30, 34 and 35 TFEU. Now, you'll want to have a treaty text to hand. I'm just going to get mine as we go through this. Bearing in mind the slide about enforcement of EU free movement of goods law, you'll need to find out and find the relevant cases to support whether these provisions are directly effective. And the key cases, and you will need to know many more cases if you're to do well in the assessment, but the key cases, if you were only to learn 3, are Dassenville, Cassis de Dijon, which we've already met, and Keck. And we'll be discussing these in the lecture. So, what obstacles can prevent goods moving in the internal market? There are basically 2 types. There are fiscal barriers and non-fiscal barriers. Fiscal barriers either take the form of customs duties, taxes paid when products cross a border, or discriminatory taxation. These are prohibited in EU law. So let's check out the text of Article 30 TFEU. Article 30 TFEU is a simple prohibition. Customs duties on imports and exports and charges having equivalent effect shall be prohibited between member states. This prohibition shall also apply to customs duties of a fiscal nature. So you'll see from Article 30 that import and export duties, but also any other charge having an equivalent effect to an import or export duty, is prohibited in EU law. And also customs duties of a fiscal nature that take the form of taxation are also prohibited. And of course, there is case law on these provisions. Please check it out from the textbooks. The treaty also prohibits discriminatory taxation. And here we need to look at Article 110 TFEU, which provides that no member state shall impose directly or indirectly on the products of other member states any internal taxation of any kind in excess of that imposed directly or indirectly on similar domestic products. Furthermore, no member state shall impose on the products of other member states any internal taxation of such a nature as to afford indirect protection to other products. So we don't cover this in a great deal of detail in this module, but note again that Article 110 prohibits both directly and indirectly discriminatory taxation. And of course, there's case law on all of these points as well. Now, as you'll remember from the Michael Dugan YouTube clip, actually, the more important type of barrier is the second type of barrier, non-fiscal barriers. And this is where most of our attention lies in the module. Non-fiscal barriers, non-tariff barriers to cross-border trade in goods. And these kinds of barriers are covered by Article 34 to Article 36 of the Treaty on the Functioning of the European Union. Now, this is a key provision for you. Again, it's a very, very simple prohibition. Quantitative restrictions on imports and all measures having equivalent effect shall be prohibited between member states. It's a very simple prohibition. A quantitative restriction is a quota or a restriction on the quantity of goods that can be imported or exported. A measure having equivalent effect to a quantitative restriction is much wider. As we'll see in a minute, it covers any rule that can have the effect of inhibiting free movement of goods. You will want to work through the textbook and make a list of the types of rules that have been successfully litigated, because you'll want to be able to recognise these when you see them in a problem question. And if you have a look towards the end of the chapter in the Craig and de Burke book, you'll see some discussion in the literature about whether this is in effect a market access test, and what it means if that is the case. That will be useful material for you in terms of an essay question. So first of all, let's think about the scope of Article 34. When does Article 34 apply? So in principle, Article 34 does not cover purely internal situations. But even if there is a potential effect on interstate trade, then Article 34 is engaged. And this is illustrated by the Pistre case, involving, as many free movement of goods cases do, a particular type of food, French cured ham. The defendants, French nationals, marketed their ham using a description, montagne, which they were not entitled to use under French food law. French food law allowed indications of montagne provenance only to be used for certain domestic products. And those French rules, were intended to safeguard the interests of producers against unfair competition and to protect consumers against descriptions of products that were liable to mislead them. The defendants were prosecuted for their use of the description montagne against the French rules. And in their defence, they argued that the provisions in question were of such a nature as to impede imports. In other words, they were MEQRs. The National Appellate Court, the French court, referred to the Court of Justice. And the court held that what is now Article 34 TFEU cannot be considered inapplicable simply because all the facts of a specific case before the National Court are confined to a single member state. Have a look at paragraph 44 of the judgment. The court went on to say, the application of the national measure may also have effects on the free movement of goods between member states, in particular when the measure in question facilitates the marketing of goods of domestic origin to the detriment of imported goods, which was the case in the case of this French law about the mountain description of cured ham. In such circumstances, the court went on to say, the application of the measure, even if it's restricted only to domestic producers, in itself creates and maintains a difference of treatment between these two categories of goods, hindering, at least potentially, trade within the EU. Have a look at paragraph 45 of the Pistre judgment. Now, this case illustrates a theme that you will see over and over again and that you will want to note in internal market law, the very wide reach or scope that it has, reaching far into domestic legal and political settlements, sometimes with cultural resonances, as is the case with this ham example. And this is a theme that Gareth Davis has noted in his work, the effect of internal market law of flattening the cultural differences between different member states to the detriment of those types of differences. And of course, you will realise that there are links between that and the democratic legitimation of the EU and the kinds of regulatory settlements that are normally fixed within a state with its democratic processes. Now, this is a slide where you will need to fill in a little bit more detail. Most free movement of goods cases are against national measures enforced by the state in question. So there's no problem, as Article 34 is vertically directly effective. In other words, it's effective against an emanation of the state. However, Article 34 is not in general horizontally directly effective. In other words, it's not in general effective against a private individual. So, for example, in the Sapod-Audiac case, it was confirmed that a contractual obligation to affix the green recycling dot to packaging provided under a directive does not come under Article 34. However, there are some exceptions to this general rule where there are official aspects to the situation. And in that circumstance, Article 34 can, in effect, be enforced against private parties. And there's a couple of examples here on the slide. And there's also another case called the Frabo case, which we're coming to in a minute, which you need to have a look at so that if you get a situation where you have a potential horizontal direct effect of Article 34, you're able to cite these cases in your answer. And these cases, of course, can also be seen as an example of the very wide reach of Article 34 TFEU as interpreted by the Court of Justice. So that's some points about scope and applicability. That seems like a pretty good place to pause, grab a drink, and I'll see you in a minute.